Greetings, everyone. Thank you for joining us for today's webinar, Unlocking 2025 Critical Updates in Background Screening Compliance. My name is Danielle Olivier, Marketing Generalist here at AccuSourceHR, and I will be your moderator today. I'd like to take this opportunity to introduce today's presenter, Jennifer Daimon, Vice President of Compliance, In-House Counsel at AccuSourceHR. Jennifer graduated from the University of Akron School of Law with a Doctor of Law degree and has over 10 years of experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal and civil record summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility service company. She has experience with government clearances and contract review. Jennifer is responsible for AccuSourceHR's compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees the quality assurance process. I will now turn the presentation over to Jennifer.
Thank you so much, Danielle. Hey, everyone. Welcome to our first compliance webinar of 2025. Before we get started, keep in mind that you can send over any questions you have during the presentation, like Danielle mentioned. I will answer as many of them as possible at the end, or as needed, I will address them by email. I know I just mentioned that this is the first compliance webinar of 2025, but we're going to start by reviewing some of the most recent updates from 2024. Many of these updates phase into 2025 or will be implemented in 2025 and beyond. I will be focusing on the following topics, but again, feel free to bring up questions in other areas that are compliance focused at the end of the webinar. Today's topics will include ban the box and fair chance legislation, salary transparency, new privacy laws, and marijuana and related updates. We will wrap up by reviewing trends in the industry in 2025 and share best practices for compliance screening programs, because we all know that it's becoming more and more important to make sure your programs are as compliant as they can possibly be. Before we get started, a quick legal disclaimer is normal. If you've been on these before, you know I always have to do this. Even though I'm an attorney, this webinar is informational only. I am not providing legal advice. Please reach out to your in-house counsel or outside counsel, preferably one who is knowledgeable in employment law, for legal advice as you review your screening programs. First topic is fair chance legislation, which will involve a number of topics in this area. For example, you may also hear some refer to these types of laws as ban the box laws. You may also see articles about clean slate laws or expungement laws. They can differ depending on the type of specific law or trend, but the general goal tends to be the same: provide a second chance, or at least a better chance to get a job or other opportunity, keeping in mind that type of language for our independent contractors or other types of parties. Take fair chance laws, for example. They may prohibit employers from asking about criminal history before a certain point in the hiring process. The goal of these laws is to allow those with criminal history to make it farther in the hiring process before criminal history is either discussed or exposed through a background check. More of these laws, though, are requiring individualized assessments, requiring a balancing of factors, in other words. Here, the employer must show that the specific criminal history justifies denying the employment or other opportunity, and they must show why, following the factors outlined in the law. And typically there's a little list that they have to balance and show that they have justification for doing so. Some of these laws are really in-depth, involving an interactive process if the individual would like to do so. So in other words, giving them the opportunity to interact with the employer and provide information that they have mitigating circumstances, they've been rehabilitated, letters of good conduct, etc. What becomes clear, though, is that fair chance is here to stay and is becoming a lot more intense. The requirements are becoming a lot more intense. If you are somehow not subject to one of these laws, you should become familiar, because at some point you likely will be, especially if you expand your footprint into different states and cities. I also want to point out that while some of the laws I'll be talking about today are already in effect, I did want to point out a quick review, as their impact is still very fresh in a lot of cases. One of these that I wanted to discuss really quick is the Los Angeles County Fair Chance Ordinance for employers, which became effective on September 3rd. The law applies to employers doing business in the unincorporated areas of Los Angeles County if those employers employ 5 or more employees. Those employees do not themselves have to be located in Los Angeles County. Keep in mind, employer and employee are both defined broadly. Independent contractors, temporary workers potentially. Looking at you, read the statutes very carefully if you already haven't done so. Due to the limited time we have today, I cannot get into the full nuances of this law, but if you are not a typical employer, make sure you check into the ordinance because it's defined so broadly. I'm also going to focus on the background screening specific requirements, but keep in mind there are other employment related requirements such as job postings and offer letters. Los Angeles County requires employers to provide candidates their written assessment with their preliminary determination or pre-adverse action letter and reassessment, assuming the candidate provides additional information that leads to the need to do a reassessment. And that reassessment would have to be provided with the final determination letter, also known as the adverse action letter, for those who are more familiar with the FCRA, for example. So far, we have not seen an official form for the Los Angeles County, from Los Angeles County, like the City of Los Angeles has provided, or New York City Fair Chance Act form, for example. I do check their website periodically. I kind of stalk them a little bit, haven't seen anything. As mentioned, an employer must provide the written individualized assessment, including by both mail and email, assuming the email is known. The notice must also list the deadline to respond in bold, caps, or underline so it is easily seen. The employer must also allow the individual the chance to present information by phone, in person, or virtually. As always, there is a waiting period in between notices. For Los Angeles County, it is 5 business days from the receipt of the preliminary letter. Remember, pre-adverse action letter is comparable name for it. However, the individual also has 15 additional business days if he or she needs additional time to obtain evidence of accuracy or rehabilitation. If the receipt of the preliminary letter is not confirmed based on how it is delivered, for example, if you send it by U.S. Postal Service with delivery confirmation, California has defined when different methods of delivery are considered received. So 5 calendar days if mailed within California, 10 calendar days if mailed outside, 20 calendar days if mailed outside the US, and 2 business days if emailed. For the final determination notice or adverse notice, in addition to the standard California content requirements, the employer must advise of the right to file a complaint with the Los Angeles County Department of Consumer and Business Affairs. Again, I mentioned earlier that if the individual provides information for the employer to consider, such as evidence of rehabilitation, letters of good conduct, at that point, the employer is required to conduct a written reassessment. If that's the case, they also have to provide that written reassessment with the final determination notice. One final thought around timeliness. In this ordinance, it's very important to not delay sending out the final determination notice where the individual has provided a timely response to the original preliminary notice. If you wait to send the final notice more than 30 days after, it will be presumed to be untimely. However, it is possible for the employer to rebut that presumption. Find a way to track it, make sure that you're not sending it late. It's not worth the risk of trying to fight that presumption with the court. San Diego County recently passed its Fair Chance Ordinance, and that had an effective date of October 10, 2024. It applies to employers with 5 or more employees which are doing business in the unincorporated areas of San Diego County. As for covered employees, it applies to employees who perform at least 2 hours of work on average each week within the unincorporated areas of the county. That includes remote work. As with other fair chance laws, employers are prohibited from taking certain actions under San Diego County's law. First, employers cannot declare in a job posting or similar listing that there are any limitations due to someone having a conviction or arrest. However, they may be allowed to do so if they're required by law. For example, a regulated industry may not allow certain types of criminal convictions, and they may be allowed to communicate that in writing. Employers are also limited to taking certain actions before extending a conditional offer of employment. First, they cannot include any question that directly or indirectly asks about criminal history in an application or similar document. Employers also cannot take adverse action against an applicant based on a criminal history information until after a conditional offer is made. Finally, employers are prohibited from asking about or considering certain items, such as convictions that have been sealed, diversion programs, or arrests not followed by conviction. San Diego also provided a list of obligations regarding taking adverse action. First, employers who intend to take adverse action based on criminal history must first provide a written individualized assessment of whether the criminal history has a direct and adverse relationship with the specific duties of the job. Interestingly, the employer is not required to provide the written assessment to the individual. If you remember earlier with Los Angeles County, I said that they did have to require it. San Diego does not have that same requirement, though. The preliminary determination notice, which is on par with the FCRA's pre-adverse action notice, does have a special requirement. It must notify applicants of their right to file a complaint with the California Civil Rights Department and the County of San Diego Office of Labor Standards and Enforcement. Moving further into the adverse action process, if the employer decides to take adverse action, it must provide the applicant with the written notice, so the adverse action notice, a copy of the background check report, and an opportunity for the applicant to respond. For my last note on San Diego, please keep in mind that employers must retain records related to all employment applications and written assessments for 1 year. So while you're not required to provide the written assessment, with the letters being sent out, you do have to retain it. Prince George's County in Maryland enacted its amended ban-the-box ordinance on September 16th of last year. This amended ban-the-box law applies to employers with 10 or more full-time employees. Covered employers cannot ask about or investigate an applicant's criminal history until after the initial interview. Even after the initial interview, employers cannot ask about or consider the following: nonviolent felony convictions that occurred 5 years earlier, misdemeanor convictions that occurred 30 months earlier, arrest without conviction, except where the result was probation before judgment, at which point the arrest would then be treated as a misdemeanor, or marijuana-related offenses, provided the sentence for the crime was completed. Unless, of course, they have to include a caveat, the conviction included an intent to distribute. lots of these laws to discuss, as you can see. This is not going away anytime soon. Clean slate, Pennsylvania. HB 689 was effective earlier last year, February 12, 2024, but then another piece of it was effective in June 2024. First, the law extended the availability of automatic expungements to offenses that were pardoned. An expungement versus a pardon are different legally. And honestly, it would lead to confusion for individuals whose records were pardoned, but then they would still appear in public records. Second, the records that are eligible to be automatically sealed have also been expanded under the law. So, for example, some low-level drug and property-related felony convictions may be sealed if 10 years have passed, assuming that that person has not had any misdemeanor or felony convictions for 10 years, of course. Many misdemeanor convictions may be sealed if 7 years have passed, with the same caveat, no misdemeanor or felony convictions for 7 years. Summary convictions will be sealed automatically after 5 years if there's no current criminal charges. The Colorado Clean Slate Law became effective on July 1st, 2024. Under the law, any arrest not resulting in a conviction will be automatically sealed. How they're automatically sealed varies based on the type of offense and how long it has been. As I just discussed in Pennsylvania, it's kind of similar in Colorado. It assumes that the person has not committed a crime in the period in between. Civil infractions require 4 years after the final disposition date. Petty offenses and misdemeanors require 7 years. Felonies can automatically be expunged after 10 years from the final disposition or release date from jail, whichever is later. There are exemptions. Violent crimes such as assault, sexual assault, robbery, and murder are not eligible. It also does not apply to records where the defendant has not fully paid all restitution, fines, or court fees related to the case. California expanded its existing clean slate law when it passed Senate Bill 731. This became effective on July 1st, 2024, and amended 2 sections of the California Penal Code. It was originally signed into law in 2022, but the effective date was delayed until 2024. It was originally supposed to go into effect in 2023. The biggest impact is that it increased the number of records eligible for relief under PC 1203.425. These are being handled through monthly audits by the California Department of Justice. If defendants don't want to wait for the monthly review process, which they're estimating could potentially take years due to the number of potential records, they can petition the court to look at their records sooner. That's kind of similar to those who are familiar, the PC 1203.4 process, where they can petition to have the dismissal. They can do the same thing for 1203.425. However, like mentioned, the process could take years, so we may see some individuals go through the same petitioning process ahead of time, so just be aware of that. Delaware already had a clean slate law in effect, but August 1st, 2024 brought implementation of the automatic expungement process part of that clean slate law. In the past, individuals were required to petition for expungement for all types of offenses. Under the automatic process, various misdemeanor and some felony offenses are eligible for automatic expungement. Some may not require a waiting period, while others may require a designated waiting period. If there's offenses that are not eligible for automatic expungement, individuals can still petition to be considered for expungement through the prior process, though. But just be aware that the automatic part of the process is officially active as of August 1st. A quick update out of Minnesota regarding its Clean Slate Act, which was passed previously. Same exact situation as I just explained. It was always the intent of Minnesota to eventually implement automatic expungement of certain types of records. It did allow for about a year for the court to kind of go through and identify those records. During that time frame, individuals were able to petition the court to have those records removed manually. As of January 1st, just a few weeks ago, automatic expungement was implemented. And for those whose records had not already been expunged through the petition process, those records should now be expunged. So if you're running any recurrent background checks, you may start to see records removed that previously would have been reported, and that is likely why. Although we will always try to double check, but of course we won't be able to see what the record is, but we can look it up and make an assumption based on the Clean Slate laws. I promise you we are almost out of Clean Slate. New York State Clean Slate Act went into effect on November 16th. Certain misdemeanors and felonies are sealed automatically. Misdemeanors are sealed 3 years from their release date from prison or from the imposition of sentence if there was no incarceration, whereas felonies, they're sealed 8 years after the same either release date from prison or sentencing date. Certain categories of serious offenses are exempted from being sealed. Class A felonies, for example, that's going to include charges such as murder, treason, arson, terrorism, kidnapping, but it does exclude certain Class A drug convictions. Sexually violent offenses and sex crimes are also exempted. Convictions will not be sealed if there are criminal charges pending or if the individual is on probation or parole when prior offenses are up for automatic sealing. Federal convictions and offenses from other states will not be sealed. It only applies to New York State offenses. If there are employers that are required to conduct fingerprint-based criminal history checks, such as those in childcare, they will still have access to criminal records, including sealed records. New York employers do have some new obligations under that law. If the background check reveals criminal history, the employer must do the following: provide the criminal history information to the individual once the employer receives it, or ensure that it has been provided. Notify the individual of his or her right to seek correction of any incorrect information, and then provide a copy of Article 23A of the New York Correction Law. This applies whether or not the employer plans to take adverse action on that criminal history. The Clean Slate Act also prohibits employers from inquiring about automatically sealed convictions or making any adverse employment decisions based on automatically sealed convictions. Finally, employers have a duty of care to prevent unlawful disclosure of a sealed conviction. Otherwise, they could be found to face a cause of action for breaching that duty of care. I promised that we were almost done, and now we are moving on to pay transparency. This topic has evolved and become more important as additional jurisdictions enact laws requiring employers to disclose compensation information. A lot of times we read and hear about these laws, but it can be helpful to understand the purpose behind them. So the goal of these laws is to facilitate pay equity, to ensure that individuals are paid the same or the same job position or title, no matter their race, gender, or any other individual protected characteristic. A lot of times when we're reading about it recently, it tends to have to do with gender or sex. When compensation data is readily available, it's easier for various parties, for example, employees, state and federal agencies, to identify and address pay disparities based on protected characteristics. So we see all this, but what's it really mean in practice? Part of the analysis involves determining whether the individuals are performing substantially similar work. Additionally, the review should also include whether there are any permissible purposes or reasons for the disparities. For example, has one person worked for the company for 10 years and another for 1 year? Does one person earn more based on merit? Does one person have a higher level degree and one person maybe has an associate's degree? What are the different positions? There can be reasons to pay someone differently from another person. You just have to take a look at everything. Pay transparency laws tend to require employers to disclose compensation information to the public or to employees in order to ensure that those parties have information to address possible pay disparities. It keeps everything fair. So let's start with Illinois, which amended its Equal Pay Act of 2003. The changes were effective January 1st and apply to all employers with 15 or more employees. The position must be physically performed, at least in part, in Illinois, or the employee would report to a supervisor, office, or other worksite in Illinois. It applies to both external and internal job postings, plus postings publicized by third parties, for example, job search sites or recruiters. Employers must include pay ranges and benefit information in all job postings. It can include other types of compensation, such as bonuses and stock options. Pay scales must be in good faith. Instead of listing all this information in a job posting, you can provide a hyperlink to a publicly viewable page that has this information. If you use a third party to post jobs, you have to provide that to the third party. And you do have to provide the information to current employees if there's promotional opportunities within 14 days of posting that position externally. Also, before asking candidates for wage expectations, employers must first share the salary range for that position. Employers do have record keeping requirements to keep them for 5 years. The Illinois Department of Labor is the one who is in charge of enforcing this, and they can investigate and take action against companies. Really, it's determined for penalties by the number of previous violations, and they can determine the amount of penalties. For active job postings, it can range from 500 to 10,000, and then for inactive, it can range from 250 to 10,000. So as you see, it could be quite expensive to violate this law. Minnesota's pay transparency provision went into effect as of January 1st. It impacts employers with 30 or more employees who are required to provide wage ranges on job postings. It includes all types of employers, including government entities, corporations, partnerships, nonprofits. Sometimes it can be limited to types of employers. This one is pretty inclusive. Job posting has to include projected salary range and a general description of benefits and other compensation. If there's no salary range, it can't be open-ended. In that case, it has to list a rate. Posting is defined as any solicitation intended to recruit applicants for a specific available position. It's not limited to being in print. It can be made electronically or in print. It does include third-party recruiting agencies, so it's not limited to just employers, for example. Agency would also have to follow those requirements. So just based on what we just discussed, Minnesota appears to be a little bit different than some of the items that we have discussed. Vermont passed its own pay transparency law. H704 went into effect, actually it's going into effect July 1st. This one applies to employers with 5 or more employees. So It applies to any job that will be physically located in Vermont or a remote position that will be predominantly performing work for an office or work location that is physically located in Vermont. It does not apply to a position that is physically located outside of Vermont and that performs work that is predominantly for an office or work location outside of Vermont. If you're in Vermont or have people in Vermont, you'll want to take a look at that very closely because that is very convoluted. Covered employer must disclose the compensation or range of compensation for position and job ads. It can be made in good faith. It is not a general announcement of job openings as far as defining for an advertisement. It has to be a specific job opening made to potential advertisements. So for example, if I were to say AccuSourceHR is always looking out for new employees, that's not considered a job posting. That would be considered a general announcement of job openings. It applies to internal and external job openings, as well as promotion and transfer opportunities. This law does have requirements for positions with tipped wages or commissions. So if you do have positions in these types of areas, make sure that you're reviewing the law closely for those requirements. If the employer violates H704, it may be required to pay restitution of wages or benefits or other relief that the courts or the regulatory agency deems appropriate. Massachusetts passed its wage transparency law, which becomes effective August 1st. First, its goal is to increase wage transparency and then close the gender-based wage gap in Massachusetts. Similar to the US EEOC, Massachusetts is requiring employers to also report that similar data to it. So you'll kind of have dual wage reporting requirements for Massachusetts if it applies to you. The second goal is to address pay transparency. It applies to private employers with at least 25 employees. You have to post the pay range for the position on all job postings. That does include promotion and transfer. If the employee or applicant requests information about the pay range, you do have to provide it to them upon request. The nice thing is there's no private right of action, but the Attorney General can bring fines. It can be very substantial, up to $25,000, so keep that in mind. New Jersey, they passed a pay transparency law as well, and that's going to be in effect as of June 1st of this year. It applies to employers with 10 or more employees, and they are also required to disclose wage or salary ranges and benefits and job postings. This one, they do have to provide reasonable efforts to announce promotion opportunities to their current employees. There's no private right of action, and the Commissioner of Labor and Workforce Development can enforce the law with civil opportunities. And again, if there are subsequent violations, this can be quite expensive, with up to $10,000 for various violations if they are ongoing. Privacy continues to be a main topic, not only in background screening, but honestly in the world. In the past on these webinars, I reviewed each privacy law separately. Because a lot of the information is similar, I'm just going to compare the various laws. I'm not going to read off the chart because honestly, that would be kind of boring, and privacy is not the most exciting topic. Sorry to privacy people, as I'm one of them too. But let's talk about the ones that are going into effect this coming year and next year. You'll see from looking at this first chart that one of the things they all have in common is that they have thresholds under which they apply. Typically, they all require that a company be selling, which that can be defined very loosely, the personal data of residents of that state. There are also numeric thresholds. For example, let's look over Minnesota. So for Minnesota, the company may meet the threshold requirement if it sells the data of 100,000 Minnesota consumers or derives over 25% of its gross revenue from the sale of personal data of at least 25,000 Minnesota consumers. Because each state sets its own thresholds, and some states set revenue amounts under which the privacy requirements may not apply, it's important to look at these thresholds very carefully. Again, I'm not going to go through this entire chart, but it's listed out here. Take a look at these laws and the thresholds because they vary state to state. How they're worded varies state to state, so it may not apply to you. Take a look at them very carefully, and the effective dates are also listed here. Yeah, there's a bunch coming up throughout the rest of this year and next year. Before I talk about some of the consumer privacy rights for these upcoming laws, I wanted to point out that these laws tend to have various entity level and data level exemptions. For our purposes today, some of these exemptions include entities and data involved with the Fair Credit Reporting Act, HIPAA, the Driver's Privacy Protection Act, and others. Employment data also tends to be exempt. I would double check to be absolutely sure, but so far from what I've seen, it most often is included in there. So privacy laws in general provide a number of rights to consumers. Some of the main consumer data privacy rights are the right to confirm that an entity has one's data, as well as the right to have access to that data. Typically, there's also the right to correction. So if there's a mistake, they have the right to correct it. The right to deletion, there typically are some exceptions to that. The right to portability, so the right to be able to get a copy of that data and take it with you. And there's other rights that are also very common among privacy laws. I'm going to review some of the more unique parts of the laws today, or point out if there really aren't too many unique parts of the different laws. So take Minnesota, for example. Data controllers are required to follow opt-out requests that are submitted through universal opt-out mechanisms. Maryland consumers, on the other hand, also have the right to be free from discrimination for exercising their rights under Maryland's privacy law. Kentucky, Rhode Island, and Indiana's privacy laws, from what I have seen, they tend to just have the standard privacy laws, the privacy rights for consumers. So really nothing unexpected to discuss there today. Some other notable information that I wanted to discuss very briefly with these laws. And keep in mind, this is just a very high level overview. They're a lot more in depth, but honestly, privacy could be an entire webinar. And there was a lot to touch on today, so very brief overview. Minnesota, controllers must have consent to process sensitive data. Sensitive data could include information revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, similar information. Minnesota is also very focused on automated profiling and artificial intelligence, so keep that in mind if you're working with Minnesota data. We highly recommend really reviewing, considering getting council review of the privacy law if you're working with AI in Minnesota, because it's very important. In Maryland, controllers are prohibited from selling sensitive data, which very similar to what I just discussed. Racial or ethnic origin, religious beliefs, health data, etc. Moving on to Kentucky, they require a consumer to opt into the processing of their sensitive data. Also important to note that Kentucky defines the sale of personal data as for monetary consideration only. I mentioned earlier that some of the information can be very loosely defined, but it's strictly sale for monetary purposes. Rhode Island, affirmative opt-in consent to collect or process sensitive data. And then finally, Rhode Island, not required to honor universal opt-out mechanisms. They also don't have a cure period. So if you violate the law, you're going to be fined without a chance to fix it. And then finally, Indiana, you have the right to appeal any business denial of data privacy right request. So if you get a data privacy request from an individual and you deny it, the individual can appeal that decision. As we move into our discussion of drug screening, let's start with cannabis, which continues to be a hot topic. Nebraska voters recently approved ballot initiative 437 regarding medical cannabis. And then a proclamation was signed on December 10th, which made it law. So they legalized medical cannabis, which allows qualified patients to use, possess, or acquire up to 5 ounces of cannabis for the alleviation of a medical condition. Caregivers can also possess or acquire up to 5 ounces on behalf of that patient. A qualified patient is defined as an individual who is 18 or older, who has the written recommendation from a healthcare practitioner. If that person is under 18 years old, they must also have the written permission of a parent or legal guardian. Specifically, employer rights or obligations were not addressed in the law. September 24, 2024, City of Pittsburgh passed an ordinance prohibiting discrimination against an individual's status as a medical marijuana patient. It also set up drug testing restrictions for employers. Please note the definition on this slide. Specifically, the Pittsburgh ordinance defines the medical marijuana patient as an individual who is certified under the Pennsylvania Medical Marijuana Act of 2016 in order to access marijuana as a certified medical use. So they are a card holder under the Pennsylvania Medical Marijuana Act. That's very important to know going forward. So the ordinance has 2 protections for those who hold medical marijuana cards under the Pennsylvania Act. It protects these patients by prohibiting discrimination in hiring or employment because of the individual's lawful status as a medical marijuana patient. Second, it prohibits pre-employment drug testing for marijuana for candidates who hold that medical marijuana card. It also limits testing of current employees to reasonable suspicion. It limits testing of current employees. You can only test them for reasonable suspicion of use or impairment at work. It does have exceptions for the medical, for marijuana drug testing restrictions for certain industries or safety sensitive job positions. So for example, if someone is a forklift driver, you can drug test them potentially based on the statute. Employers are allowed to prohibit the use of medical marijuana in the workplace, and they can test for reasonable suspicion. Because this went into effect immediately when it was passed, if you aren't already in compliance, you should review it immediately to see what you need to do to get into compliance if it impacts you. So I normally don't spend too much time on case law, but I did want to kind of discuss a couple of them very, very briefly to kind of show how different things could be from state to state. In the first case out of Florida, the plaintiff, Giambroni, was employed as an EMT for Hillsborough County. He was chosen for a random urine drug test. After testing positive for marijuana, he provided a valid medical marijuana card. He was placed on administrative leave by the county, but there are no other complaints or allegations made by his employer. The employer did report him to the EMT licensing board, However, the board dropped its investigation for lack of probable cause because Giambrone did possess the medical marijuana card. Giambrone did sue his employer, alleging disability discrimination for failure to accommodate under the Florida Civil Rights Act due to his anxiety and insomnia, which he used the marijuana to treat. The court found that he was a qualified patient suffering from anxiety and insomnia that significantly impacts his day-to-day life when unmedicated. They also found the law in question does not require accommodations for any on-site use of medical marijuana. They also found that that employers are required to accommodate the off-site use of marijuana by qualified patients. Therefore, he was protected under the Florida Civil Rights Act and was entitled to a disability accommodation. So based on this, if you're an employer in Florida and test for marijuana, you should definitely review your treatment of medical marijuana card holders to ensure that you're taking this case into consideration. In Anderson versus Diamondback, the plaintiff Anderson was terminated for failing 2 drug tests. She used hemp-derived products, including CBD oil and other products, during non-working hours. She stated that the products she used were legal, never made her high or affected her work performance, and that she never smoked marijuana or used illegal drugs. After testing positive twice, she was terminated under the drug testing policy of her employer. She sued Diamondback for first, disability discrimination under the Americans with Disabilities Act, 2, failure to accommodate under the ADA, and 3, discrimination for the alleged lawful use of lawful products during non-working hours. So it went through the court system, and upon appeal, the Fourth Circuit held that Diamondback was free to implement its drug testing policy, resulting in the termination of an individual taking a drug test that showed an illegal drug to treat a disability, assuming that the policy does not exclude that drug to treat a disability. For her failure to accommodate claim, they also found that she did not request a reasonable accommodation in the first place, so that claim did not work. Finally, she had argued that she should have been able to use the hemp-derived products under North Carolina's lawful use of lawful products law. However, she didn't prove that the products that she was using were actually legal in North Carolina. So ultimately, you can see that this finding is beneficial to employers in North Carolina. And one more quick case. The employer in this case had implemented a drug and alcohol policy that prohibited the lawful use or the unlawful use of uncontrolled substances in the workplace, including marijuana. Employees were required to undergo random drug screening as part of this policy. The policy also had a process in place for first-time positives and subsequent positives, including counseling programs, then leading up to termination for subsequent positives. The employee, White, tested positive for marijuana on a random drug test. He did participate in a program, and he continued to work during that time, but he wasn't allowed to drive a company vehicle. After several follow-up tests, including negative dilutes, he ultimately tested positive for marijuana. White was terminated for violation of the employer's drug and alcohol policy. White sued for violation of Illinois Right to Privacy in the Workplace Act. This policy or this law prohibits an employer from firing an employee if the individual uses lawful products off the premises of the employer during non-working hours. And cannabis is now a lawful product under that law. So that was the argument there. The court ultimately found that zero tolerance policies don't need to be tied to in the workplace conduct as long as they're enforced through reasonable and non-discriminatory random drug testing, and then ultimately Timken's policy was fair and enforced reasonably. So ultimately they were fine with what they with the actions that they took. So it's been talked about for many years about how marijuana is going to be handled on a federal level. The Drug Enforcement Agency has proposed rescheduling marijuana from Schedule 1 to Schedule 3. I'm going to go through this very briefly because I want to make sure we have time for questions. Basically, if they reschedule it, it's not going to fully legalize it on a federal level. However, that being said, it would put it on the same level as ketamine and anabolic steroids by changing it to a level 3, a Schedule 3. This could potentially create concerns for employers going forward, especially under the Americans with Disabilities Act, because at that point, being Schedule 3, there could be concerns about accommodating employees who are using marijuana for medical purposes. This is still ongoing. Ironically, there was a hearing scheduled for today, January 21st, that's been postponed due to an appeal. We continue to watch this. We'll keep watching and let you know what we hear. We are a quarter of the way into the century, and what can we expect as we continue moving forward? We are not lacking for fair chance and related laws, and we're going to keep seeing them. Pay transparency laws, I spent a bunch of time on that as well. We're going to keep seeing those. It's going to be interesting to see what happens as we move forward further into this year as well, and I'll get into that in a minute. As you saw, we have a bunch of privacy laws coming into effect. I didn't see anything coming up super far into the future, so I'm going to keep seeing if there's any more on the horizon as well. I'm sure there are. Haven't seen as many marijuana laws, but as you can see, there are cases coming through the courts, and there's a lot of conflicting information out there between the states. So definitely some questions for employers on a national level. And the interesting thing is we are going into a Republican Congress, House, Senate, and presidency, and we tend to see a more conservative approach towards background screening. We're likely going to see some regulatory changes as well. Stay tuned to blog posts, future webinars. We're going to keep watching everything very closely, and we'll publish updates as we see them. Before we take questions, want to recommend some best practices. Always make sure you're comparing any of your application documents and hiring processes against ban the box and fair chance laws. Everything's constantly changing. Review at least annually. At this point, you might have to do it more. Just be aware of what's going on. Update your hiring processes based on pay transparency requirements. Watch for reporting requirements as well, as Massachusetts has one for EEOC type data. Determine how new privacy laws impact you. There may be exceptions, but be careful, not all data falls under that. And then also be aware of any drug screening or marijuana changes that are coming your way, since they may impact your programs as well. It's always best if you have any concerns, or honestly, even if you don't, have a privileged review. So that way, if you do have any concerns or something weird comes up, it's protected. We're now at the end of the presentation, and we'll now take questions, and I'll pass it back over to Danielle.
Thanks, Jennifer. We'll dedicate the remainder of the webinar to addressing attendee questions. So the first question that we have is there a limit on the number of times an employer can run a criminal background check on an employer? Sorry, on an employee, I apologize.
Yeah, so it's kind of a yes and a no. So if you have someone who's an employee, and as long as you have what's called evergreen consent in your disclosure and authorization form, specifically the authorization, So authorization to run pre-employment and during employment, then yes, you can, as long as there's been no break in employment. However, California is an exception because they don't allow evergreen. Not going to give away the tricks of the trade, but you do need new consent for California because they do not allow ongoing consent.
Perfect. The next question that we have is on pay transparency on job postings. Do you have to list the entire salary range or the compensation you are offering for that specific job opening?
Yes. So I think it's going to vary based on the jurisdiction. I know it's really hard for national employers, and I've seen employers who have kind of specified, like if they're national, that the pay ranges may vary depending on different localities, because of course there's certain like New York City and some of the locations in California may have much higher ranges. So the pay range can be like hundreds of thousands of dollars different potentially just because of that. So I've seen some caveats on the pay ranges, but it's hard, especially with remote positions, to kind of target it. But yes, the goal of these laws is to list the true pay range. But also, they also don't want them to list any possible pay range. Like you can't just say like, oh, we could pay someone $10 to $500,000. That's not realistic either. It has to be good faith. So check the laws that apply to where you could potentially be having candidates. And worst case, get a privilege review of what you're trying to do. That's really the best bet. That's what I would do, honestly. As I'm not HR counsel, I do these, but if we had a weird situation and we weren't 100% sure, I would seek outside counsel, to be honest.
Great. Another one to the pay transparency. Do employers also have to supply the salary range to an existing employee for their current role?
It depends on the law. Some laws do specify that if the employee requests that information, then yes, you do have to supply it, but it really depends on the specific law.
All right. We're almost at the end of our time, so this will be the final live question. Again, attendees, if you entered a question into the chat box and we didn't have the opportunity to address it live, our team will follow up with you directly post-webinar to provide an answer. So the last question that we have is, when running a background check, why some employees have sex offenders ran and others not? Shouldn't all employers search should be the same? Sorry, shouldn't all employee searches be the same?
So it really depends how the package is set up. I personally think that all background checks should include a sex offender search. And I know that the way that we run them, the sex offender search is included in one of our base searches. It just depends how it's listed on the report. That being said, there are reporting restrictions, so we may not be able to report it back to you, depending on what happens. There are a lot of there's a lot of complications that can make it difficult for us or illegal, honestly, for us to report things. If you have a specific question about something or any concerns and you're a current client, please feel free to reach out to customer success or reach out through the marketing team and we can address that for you. And if you are not a current client but have questions about it, please feel free to reach out and we can absolutely discuss with you as well because we are happy to help.
Thank you, Jennifer, for facilitating this informative webinar, and a special thank you to our attendees for joining us today. If you have any additional questions, please contact us at marketing@AccuSourceHR.com. On behalf of the AccuSourceHR team, we wish you all an enjoyable day.